Good morning, right? Only one participant has joined. Dilini, do you remember where we stopped in our previous session?
Good morning, sir. We are stopped at slide number 83.
83, yes. Rights and privileges, rights and liabilities
Yes.
of trade union. So,
Yes,
83 we discuss actually, right?
yes.
And from 84 onwards, 84
Yes, sir.
was, yes, and because this is something like the ILO convention, the right privileges and rights of the members of the trade union, right? ILO Committee on Freedom of Association 2018, there was a complaint, right, against a country. So decision what was the decision? The ILO Freedom of Association, the report. This is, some other information in relation to emphasize, emphasize the privileges and rights of the members of trade union. It is recognized at the international level. Examples. ILO Committee on Freedom of Association, it says trade unions should be able to hold meetings without without the need of communicate the agenda to the authorities. In accordance with the principle embodied in Article 3 of the Convention 1987, whereby organizations have the right freely to organize their activities without interference from the authorities. So these are background or supportive information that we have in order to emphasize. Just give me 1 second, right? Just 1 minute. So people have, it is right, inviolable rights, anulanganiya, inviolable rights of the trade union. So these are some background information in order to emphasize the rights of the working people, the freedom of association. Okay, right. I would like to draw your attention, ladies and gentlemen, to the special provisions made and applicable to trade unions of public officers. At the time this ordinance was enacted, there was no provision included in the trade union ordinance with regard to the union rights of public sector workers or public officers. Amending this ordinance, right, under amendment number 15 of 1948, the special provisions were made to grant rights and privileges to public officers. When this act was enacted, do you remember? When this Trade Union Act was enacted, what is the number and the date? Sorry, year? Tilini? Are you there? Trade Union Ordinance, number 14 of 1935. Number 14 of 1935. Okay. So then in 1948, this ordinance was amended, in order to provide or grant trade union rights for the public sector officers or workers or public officers. Madhusanka, is it clear? Who is there? Nobody? Okay. So now, subtopic, subtopic. Take your note, right? Amendments number 15 of 1948. This is the subtopic. Amendment number 15 of 1948. Okay. Amendment for what? Amendment to this ordinance. We are talking about the trade union ordinance, right? So amendment was brought, right? So take your note. Do you hear me?
Yes, sir, we can hear you.
Right. Amending or amending the trade union ordinance in 1948. In 1948, special provisions were made to grant rights and privileges to the sorry. special provisions were made to grant rights and privileges to public officers, subject to certain restrictions. Subject to certain restrictions. Certain restrictions. Okay. Now, amending this ordinance in 1948, public officers were granted privileges. Public officers were granted privileges, and the rights and privileges were granted to the public officers subject to certain conditions. So then we have to understand what are the restrictions, right? Subject to certain restrictions. Okay, right. The next slide talks about this situation. Special conditions relating to trade unions of government staff officers and peace officers, right? In the case of a union of peace officers or government staff officers, in addition to the provisions referred to in paragraph 21A, provisions declaring that the union shall not be affiliated to what are the restrictions? There are let me tell you like this, right? Here in my previous slide, I discussed, I explained the rights were granted, but there are restrictions. What are those restrictions? Special conditions relating to trade unions of government staff officers, right? Staff officers, right? The staff officers. Special conditions, right, relating to trade unions of government staff officers and peace officers. Government in a provision declaring that the union shall not be affiliated or amalgamated or federated with any other trade union, whether or public officers or otherwise. What does it mean? So, government staff officers union, look at, let me read once again. A provision declaring that the union shall not be affiliated to or amalgamated or federated with any other trade union, whether of public officers or otherwise. What does it mean? Government staff officers, right, trade union, they cannot federate government, but there are provisions. Look, the second one, a provision declaring that the union shall not have any political object or political fund with the meaning of section 47 of the ordinance. Let me put it into simple language. Okay, there are restrictions. What are those restrictions? One is government sector, any government sector trade union cannot be affiliated, federated or amalgamated with the private sector organization, private sector trade union. That is one. Even within the government sector, different trade union cannot get together and form a federation or federation or affiliation. But except staff officers union, all other different union in one particular organization can form a federation. Health sector trade union alliance is the classic example. Health sector trade union alliance. Except GMOA, Government Medical Officers Association, there are plethora of trade union, drivers union, nurses union, different, and radiologists union. There are plenty. So they, within one organization, it is what we call, how we call this vertical integration. Within one organization, there may be different trade union. So except the staff officers union, all other union can form a federation. Okay, do you understand?
Yes, sir, understood.
Okay, right. So don't put without putting, this word, next subtopic, restrictions. Restrictions, because we refer to that word in our previous slide. Right. Restrictions. Restrictions. Number one. Government sector trade union cannot join with private sector trade union and form an affiliation or a federation. A federation. Number two, even among the government sector trade union or public sector trade union, government or public sector trade union, cannot federate or affiliate themselves full stop. However, there are two exceptions. With regard to amalgamation stroke affiliation stroke federation of public sector trade unions. Simple A. If there are more than one trade union, registered trade union in one particular public sector organization, comma, except staff officers union, other unions within that organization can affiliate or amalgamate or federate, whatever the word. Right. Simple B. Simple B. Simple B. The government, sorry, not government, don't use the government, public sector unions in different organizations, operating in different organizations. Different organizations. What I said, Dilini, can you repeat it?
The public sector unions operate in different organizations.
Operating in different organizations can form a federation based on the nature of their work. Within bracket, similar nature, right? Similar nature. It is put a similar nature. What does it mean? Let me explain. There are drivers union, you know, in different organizations, different government organizations, right? The health sector, there is a drivers union, a health sector or health ministry drivers union. Public administration ministry drivers association. And then Kalmanakarana Sahakar, management assistant organizations. It is, you know, registered branches are there everywhere in the country. These nature is similar. Nature, you know, similar nature means drivers are similar. Wherever you work in a government organization, drivering, you know, is similar. And then the management assistants, their work is similar, right? In similar nature. So they can get together and form a major trade union. Okay? Oh, federation rather. Do you understand what I said? Pavani, is it clear? Dilini? I can't hear, you know, any voice.
Yes, sir, understood.
Okay, right. So looking at the similar nature, you know, like this, drivers association of the health sector, right, cannot be affiliated with or with management assistance association operating in the public administration. It is not possible, but they can have a federation looking at the similar nature. Drivers working in health sector, they have an association, registered one. And the drivers association, even the Department of Labor, drivers association is their registered one. Agriculture department, drivers, right, union is their operating a registered one. So all these drivers union operating in different government organizations, can get together and form a major federation. That is possible. Otherwise, no. Okay, right. Next, number 3, restrictions. You know what we are. So don't put the number 3. Next subtopic. Right. Subtopic exclusion. Exclusion of public officers from organizing trade union. Asanta. Exclusion of public officers from organizing trade union, right? There are public officers who do not have trade union right, meaning that they cannot organize, they cannot establish trade union, and they are not supposed to join trade union as well. Forming and joining trade union is prohibited for these officers. Joining and forming trade unions are prohibited for the following categories of public sector officers. Who are they? Judicial officers, members of the armed force. They may be having welfare society, but not trade union. Police officers, prison officers, or the last one, the members of any crops established under the agriculture crops, right? So this is the number E is not operating right now, right? So therefore, judicial officers, members of the armed forces, police officers, prison officers, they do not have trade union right. They cannot form trade union and they cannot join trade union. Is it clear?
Yes, sir, clear.
Right. Take your note. There are certain categories of public officers who do not have trade union rights. Who do not have trade union rights. They have been excluded. They have been excluded excluded from organizing trade union. Accordingly, the following officers, of public sector have been excluded from this ordinance by this ordinance from organizing trade union. They cannot organize and join trade unions. They cannot form, not organize. They cannot form and join trade unions. Right. Simple A, judicial officers. Simple B, members of the armed force, 3 forces, right? Army, Navy, Air Force, members of the armed forces. Members of the armed forces. And then number C, or number 3, police officers. Police officers. D, prison officers. Prison officers. Prison officers. Then E, members of any corps, any corps, corp, established under the agricultural corps, within bracket, this is not in operation at present. Number E is not operating at present. Close the bracket. close the bracket. And then next, ilanga ruler, next ruler, next, not Farah, close the bracket, be deemed not to be a trade union. Be deemed not to be a trade union. What does it mean? They don't have trade union rights. Okay. Taksini, is it clear? Tassini, sorry. Right. Now, we are going to discuss something about strike. Subtopic is a strike. Strike. You have seen in Sri Lanka, in real world, many strikes. You might have experienced it. Plethora of strikes in this country. Mainly the public sector trade unions, health sector, the education sector, principals association or union, and then teachers unions. They were fighting and they were undertaking a strike action, keeping, the students. I don't know how it could be explained, but it's pathetic situation. Everywhere, doctors, even for simple matters, they go for strikes. Even some private sector organizations, private companies, they go for strikes. So plethora of strikes in this country. So what do we mean by strikes? According to the Trade Union Ordinance, Section 2, strike means the cessation of work. වැඩ නැවැත්වීම නැත්නම් වැඩ නොකර සිටීම. Cessation of work by body of persons or group of persons employed in any trade or industry acting in combination or connected, refusal under a common understanding of any number of persons who are or have been so employed to continue to work or to accept employment. Strike means the cessation of work by body of persons employed in any trade or industry. That is the simple one. Acting in combination, right? This is some additional thing. Acting in combination or concerted refusal. I made a mistake, really sorry. Concerted mistake. Concerted refusal under a common understanding of any number of persons who are or have been so employed to continue to work or to accept employment. I'm repeating, ladies and gentlemen. Strike means the cessation of work. By whom? By body of persons employed in any trade or in any industry. Acting in combination, or a concerted refusal. Podu refusal, ප්‍රතික්ෂේප කිරීම. Under a common understanding, පොදු එකඟතාවයක් understanding of any number of person, මිනිස්සු අතර තියෙන පොදු එකඟතාවයක් අනුව මොනවා කිරීමද? වැඩ නැවැත්වීම. Cessation. It may be temporary. 1 day or 2 days, maybe dragging for a couple of months. Okay? Dilini, is it clear? Because
Yes, sir.
only you are the only one who is responding when I raise questions. But I have noticed that some I am giving chances and repeatedly asking whether you understand, it is understood or not. And no one except very few people, others, you know, they are silenced, but later complain that they don't understand. So what a shame, what a shame. So I'm asking, if you do not understand, let me explain once again, right? Until you can understand. Okay. Subtopic strike. One word, just. Strike. Strike means the cessation of employment. Cessation of work, sorry, work, not employment. Cessation of work. By whom? By body of persons. Maybe a trade union. Body of persons employed in any trade. Employed in any trade. Any trade or industry. Acting in in combination or concerted, concerted, concerted refusal. Refusal under a common understanding. Concerted refusal. Samohika pratiksepa kirim. Right. Under a common understanding. පොදු තේරුම් ගැනීමක් සහිතව පොදු එකඟතාවයක් සහිතව of any number of persons who are කවුද මේගොල්ලෝ මේ එහෙම කරන අය who are or have been so employed දැනට සේවයේ නියුක්ත කරලා තියෙන comma to continue to work or to accept employment. This is the definition within bracket section 2 of the Trade Union Ordinance. Section 2 of the Trade Union Ordinance. Right. Now, ladies and gentlemen, if I raise this question is, the race by international organizations in particular, right to strike, right? Yes, we say that we have the right to strike. We can go for strike. Has it been explicitly expressed in any legislation? That is the question. The right to strike, ILO is saying, no, you have to legislation, any trade union law or whatever it is, it has to, specifically say that people have the right to strike. But any of our legislation does not say that, does not have provisions in regard to right to strike. Constitution, yes, we do have constitutional provisions. Article 14D, it says the workers, people have the right to form trade union and join trade union. The trade union also, the provisions of trade union ordinance are also guaranteeing the freedom of association. But neither constitution nor trade union ordinance say neither constitution nor trade union ordinance have provisions, written provisions in relation to right to strike. Do you understand? Right to strike.
Yes,
Yes.
sir, clear.
Right. Right. Not set out explicitly even in ILO conventions. Not set out explicitly in any legislations in Sri Lanka, but recognized by necessary implications in the labor legislation. Recognized by necessary implications in the labor legislations. Okay. Next subtopic, right to strike. Right to strike. Right to strike. First bullet form. First bullet form. Not set out. Not set out. Explicitly in ILO conventions, within bracket convention 87, convention 87 and 98. Next bullet form. Not set out explicitly in any legislations. ඒ කියන්නේ ස්ට්‍රයික් කරන්න අයිතිය තියෙනවායි කියලා ලිඛිතව තියෙන්න ඕන කියලා කියනවා ILO එක එක්ස්පර්ට්ස්ලා. but even ILO convention එකෙත් එහෙමම නැහැ. අපේ දේශීය legislation වලත් එහෙම නැහැ. ස්ට්‍රයික් කිරීමට අයිතියක් තිබේ කියලා වචනයක් ක්ලෝස් එකක් කොහෙවත් දකින්න නැහැ. ඒකයි මේ කියන්නේ. right? Not set out explicitly in any legislations. Third bullet. Recognized by necessary implications in the labor legislations. In the labor legislations. Right. Then I would like to draw your attention to this slide. Does an employee have a right to strike? No legislation explicitly is saying that a worker has right to strike. But strike is accepted anywhere in the country. Legal strikes. Without damaging to property, you can undertake a strike. So we have decisions, court decisions in that regard, even though we do not have, the explicit provisions, right? Provisions explicitly mentioned in any legislation. Our court system has developed this one. How? The court, the Best Footwear Private Limited versus Minister of Labor and others in 1997. Let me read out this. Read this out. The court took the view that the right to strike has been recognized by necessary implications in the industrial legislation in Sri Lanka. And there are numerous express statutory provisions providing for the regulation of strikes, and that it is thus. So some spelling mistake. A recognized weapon of workmen to be resorted to by them for asserting their bargaining power and for promoting their collective demands upon an unwilling employer. මේක සේවකයන්ට තියෙන වෙපන් එකක්. collectively bargain කරන්න. තමන් කියන දේට ඇහුම්කන් නොදීමට සූදානම් නැති හාම්පුතෙක් එක්ක bargain කරන්න තියෙන වෙපන් එකක් හැටියට හඳුන්වනවා. The next case, In the case of Rubber Company Limited versus Labour Officer Colombo, the court held that the Industrial Disputes Act recognizes a basic right of workmen to commence and to participate in a strike, to express their grievances, and to win their demand, subject to restrictions and prohibitions specifically laid down. Right? In the case of Abu Salih, former Minister of Labor versus Vocational Training and others, it was held that the workers had a right conferred on them to launch a legitimate strike. So look, our court system has recognized. There are some provisions in the industrial, not directly, but some provisions in the Industrial Dispute Act as well. Next para. However, next para. However, our court system within bracket superior courts, superior means Supreme Court and the Appeal Court. These are the superior courts. Our court system, has recognized the right to strike. The right to strike. The right to strike. Just give me 1 second. Sorry. Dilini, can you repeat? Can you read it out?
Recognized to right to strike.
Has recognized the right to strike. Recognize the right to strike. Okay.
Okay, sir.
Following are the examples. Following are the examples in that regard. In that regard. Following are some of the examples in that regard. Number 1, best footwear. Best, B-E-S-T, best footwear. PVT, within bracket PVT, private, close the bracket LTD, limited, versus Minister of Labor, within bracket 1997. 1997 to SLR 139. 2 means volume 2. SLR Sri Lanka Law Report. Right. And then this is the source. Number 2. Number 2. Rubber Company Limited versus versus Labor Officer Colombo. Number 3, or bullet number 3, oh yes, number 3. Abusali, Abbosally, Abusali, comma, former Minister of Labor versus VS versus vocational training and others. Okay. These are examples, right? Now, we will look at, some practical issues and practical problems with regard to strike and vacation of post, right? And probationer and the right to strike, whether probationer has the right to strike, and union recognition, right? And trade union actions. What are the trade union actions? Right. Okay. So now next subtopic is strike and vacation of post. Strike and vacation of post. Strike and vacation of post. So, what do you mean by this? Okay. The Industrial Dispute Act, ladies and gentlemen, recognizes a basic right of workmen to commence and to participate in a strike to express their grievances and to win their demand, subject to the restrictions and prohibitions that are specifically laid down. Specifically laid down. Strikes and vacation of post, right? So what is we are dealing with trade union ordinance, right? The employer could not validly issue an ultimatum to workmen on a lawful ultimatum to workmen on a lawful strike, requiring them to report to work before a specified date, or in the alternative, be considered as having ceased to be employees, or as having, right, abandoned their employment. This is also extracted from or derived from the court decision. What does it mean? If you are undertaking, you means your organization or whatever it is, trade union, you are, right, on a strike action. You are not reporting to work. So, while you are engaging in a strike action, your employer cannot force you to report to work on or before a certain date. And if you do not fulfill this one, it is considered that you have abandoned your work. It means you have, vacated your post. So this kind of letter cannot be issued. So even during the strike period, your employer cannot terminate you, right? Cannot ask you to report. Yes, they can ask, in friendly manner. Okay, okay, even they can send a letter asking to report, right, report to work before, on or before a certain date. If you do not report, during the strike action, remember that if you all are undertaking strike, so then the employer may issue a letter asking you to report to work, right, before, on or before a certain date. You decide, the union decide, no, we will undertake strike. So in such a situation, your employer cannot consider that you have abandoned or vacated your post. Employer cannot issue a vacation of post letter because you are in a strike action. So that is how the legal system in Sri Lanka has recognized the union right or strike. Do you understand?
Sorry, sir, I am unable to understand. Can you explain in Sinhala?
Okay.
Yes, sir, it's good in when you are understanding it Sinhala also.
Okay. Hari. මම සිංහලෙමුත් කියන්න. දැන් ස්ට්‍රයික් පීරියඩ් එකක් ඕගොල්ලෝ නිරත වෙලා ඉන්නවා නම්, right, යූනියන් එකක් විසින් ස්ට්‍රයික් ඇක්ෂන් එකක ඉන්නවා. එතකොට හාම්පුතාට පුළුවන් අහවල් දිනයට කලින් වැඩට පැමිණිය යුතුය. නැතහොත් ඔබ සේවය හැරගියාසේ සලකා කටයුතු කරනු ලැබේ කියලා ලියුම් යවන්න බෑ. ලියුම් යවන්න පුළුවන්. හැබැයි සේවය හැරගියාසේ සලකන්න බෑ. ඔබට ස්ට්‍රයික් ඉන්නකොට ලියන්න පුළුවන් හාම්පුතාට අහවල් දිනයට කලින් වැඩට පැමිණෙන්න. එසේ නොමැතිවහොත් ඔබ සේවය හැරගියාසේ සලකා කටයුතු කරනු ලැබේ. ඒ කියන්නේ වැකේෂන් ඔෆ් පෝස්ට්. ස්ට්‍රයික් එකයි සේවය හැර යනවා කියන්නේ වැකේෂන් ඔෆ් පෝස්ට්. මේ දෙක අතර තියෙන සම්බන්ධය. ස්ට්‍රයික් එකක් වෙලාවේ එහෙම කරන්න බෑ. ඒක නීතියෙන් තහනම්. පැහැදිලිද?
Oh, sir.
හරි. ඒකයි මේ කියන්නේ. ඒක තමයි මේ කියන්නේ. The employer could not validly issue, right? issue කරන්න බෑ. And ultimate, right? Ultimatum. ඒ කියන්නේ අවසානාත්මක. ඒ කියන්නේ සේවය හැර යාම හරි කියන්නේ අවසන් කිරීම කියන්නේ. To work on a lawful strike, requiring them to report to work before a specified date, or in the alternative, be considered as having ceased to be employees or as having abandoned their employment. ඒ කියන්නේ ඔබ සේවය හැරගියාසේ සලකා කටයුතු කරනවා වැඩට ආවේ නැත්නම් කියලා හවල් දිනේට කලින් කියලා ලියුම් ගහන්න බෑ කියන එකයි කියන්නේ. ගැහුවත් ඒක වළංගු නැහැ. තේරුණාද? දැන් පැහැදිලිද?
Yes, sir. Now it's clear.
Right. So this cannot be applied for a normal situation. This is applicable if workers are, during the strike period. Okay. This provision is only applicable. This situation is only applicable when there is a strike. Okay. In a normal situation, so employer, if you do not report to work, right, getting prior approval or having not without informing, so definitely employer will issue a letter of what you call vacation of post letter. That is possible. It is legal. But during a strike period, for workers, those who are undertaking a strike, they cannot be asked to return to work before a specified date. And if not, considered as you have vacated your post. No, that is not possible. I hope you understand right now. Right. What was the topic? Okay, before we take this note, We will go for a break. Now is 10:20 until 10:35. We will be having a break. 10:35. Okay.
Okay, sir.
Right. If you do not understand in English, don't hesitate to ask in Sinhala, right? I'm ready to explain in Sinhala as well. But if you do not understand, I mean, sometimes the legal jargon, right, it's not familiar, right, for you, right? It is somewhat, difficult to understand. So let me know. I will explain in Sinhala. No worry about that. Okay, right. Go for a break until 9:35. Sorry, 10:35.
Excuse me, Dilini. Hello, Dilini. Excuse me, Sydney.
Well, right. We are on time, so we will start. Right. Strike. The topic is strike and vacation of post. First para, the Industrial Disputes Act. The Industrial Disputes Act. When you write act, A capital, always for a law. If you put simple A, then kriyakarakam. So නීතියක් ගැන කියන හැම වෙලාවම act කියන වචනේ එනවා නම් A capital, right? The Industrial Disputes Act recognizes a basic right of workmen to commence and to participate in a strike to express their grievances and to win their demands subject to the restrictions and prohibitions that are specifically laid down. මේකේ තේරුම තමයි කාර්මික ආරවුල් පනත කියන්නේ කම්කරුවෙකුට යම් restrictions වලට prohibitions වලට යටත් වෙයි. ඒ කියන්නේ අර amalgamate වෙන්න බෑ කියලා අපි කලින් කිව්වනේ, federate වෙන්න බෑ, right? drivers ලගේ දැන් ඒවයි යම් restrictions ටිකක් කිව්වනේ අපි නේද? ඒ restrictions වලට යටත්ව කෙනෙකුට වෘත්තීය සමිතියකට සේවකයින්ට ස්ට්‍රයික්ස් පටන් ගන්න, ඒවට පාටිසිපේට් වෙන්න අයිතියක් තියෙනවා. කුමක් සඳහාද? තමාගේ grievances දුක් ගැනවිලි සහ තමන්ට ලැබෙන්න ඕන අයිතීන් යම් අයිතීන් දිනා ගැනීම සඳහා වෘත්තීය ක්‍රියාමාර්ගවල ස්ට්‍රයික්ස් වල වැඩවර්ජනවල නිරත වීමේ අයිතිය තිබේ. right? ඒක තමයි ඒකෙන් කියන්නේ. මේක එන්නේ නඩු තීන්දුවකින්. ඒ නඩු තීන්දුව තමයි Ruberoid Company Limited versus Labour Officer නිගම්බු කියන මේ නඩු තීන්දුවෙන් තමයි මේක එන්නේ. හරි. දෙවෙනි පැරා එක. next පැරා. The employer could not validly issue an ultimatum to workmen. Workmen. ගොඩක්. මන් කිව්වොත් එක්කෙනයිනේ workmen. On a lawful strike. නීත්‍යානුකූල වැඩ වර්ජනයක. Lawful strike. Requiring them to report to work before a specified date or in the alternative be considered as having ceased. Cease කරනවා කියන්නේ ceased. ඒ කියන්නේ නැති වෙනවා කියන්නේ ceased. To be employees. ඒ කියන්නේ සේවකයෙක් ලෙස නොසලකා හැරීමට කටයුතු කරනවා කියන එක. or as having abandoned their employment. ඒකෙන් කියවෙන්නේ යම් සේවක කණ්ඩායමක් වෘත්තීය ස්ට්‍රයික් එකක නිරත වෙලා ඉන්න වෙලාවක යම් දිනයකට කලින් නැවත සේවයට පැමිණිය යුතුයි කියලා අල්ටිමේට් අවසානාත්මක නිවේදනයක් යවන්න හාම්පුතෙක් නොයවිය යුතුයි. ඒ වගේම එහෙම යවලා ඒ දිනේට ආවේ නැත්තම් සේවය හැරගියාසේ සලකා කටයුතු කරනවා කියලා කියන්නත් නොකළ යුතුයි. එහෙම කියන්නත් බෑ. right. එහෙම සේවය හැර යාමේ ලෙස සලකා කටයුතු කරන්නත් බෑ ස්ට්‍රයික් වෙලාවකදී. ඒකයි මේකෙන් කියන්නේ. මේක එන්නේ මොකෙන්ද? the above decision has been cited right in the following court decision. ඔබට පේනව නේද මේ do you see the slide trade unions ordinance 1935 strike and vacation of post පේනවද?
ඔව් සර්.
right මොකද්ද කම්පැනි එකේ නම? මෙන්න නඩු තීන්දුව. Robite RUBBERITE Company Limited versus VS V විතරක් දැම්මත් ඇති dot. Labor officer Nigambu within bracket 1990 close the bracket to Sri LR SLR or Sri LR SRI L capital R capital dot 42 SLR or Sri LR means Sri Lanka Law Report. Okay, I hope you understood. Right. ඊළඟට අපි බලමු probation and right to strike කියන එක. probation කෙනෙකුට වැඩ වර්ජනය කිරීමේ අයිතියක් තිබේද? ඒකත් තීරණය වෙලා තියෙන්නේ නඩු තීන්දුවකින්. එහෙම නැතුව trade union ordinance එකේවත් industrial dispute act එකේවත් ලියලා නැහැ. probation කෙනෙකුට strike කරන්න අයිතියක් තියනවද නැද්ද කියන එක ලිඛිතව නැහැ. නමුත් ඒක තීරණය වෙනවා නඩු තීන්දුවකින්. So whether probationer has the right to strike. Okay. Topic is whether a probationer has right to strike. සරලවම දෙන්න තියෙන උත්තරය yes. හරි? ඔව්, අයිතියක් තියෙනවා. Probationer, even probationer has the right to strike. It is not stipulated in any legislation, but the court has accepted that, court system has accepted that probationer also has the right to strike. Okay, so we have court decision, court case in this regard. That is the Ceylon Mercantile Union, CMU in short, versus Ceylon Cold Stores Limited and another Supreme Court nadu තීන්දුවක්. CS means always Supreme Court. 1995. One is volume. Sri LR 261. Page number 270. Okay. It says the judge has said that, judge, let me quote what judge has said. I'm quoting. I have no hesitation in holding that a probationer has as much a right to strike as a confirmed workman, and the proper exercise of that right cannot place the probationer in jeopardy, right, insofar as the employer's right to terminate his service during the period of probation is concerned. And I'm again quoting, it is not open to an employer to punish or dismiss his employee slowly or principally for the reason that he had joined a trade union, where therefore the circumstances that an employee had joined the trade union had at least partially, right, weighed with the employer, it would be an act of victimization, and the punishment, right, inflicted on the workman on this consideration would be unjustified. මේකේ තේරුම මෙහෙමයි. probation කාලේ වෘත්තීය සමිතියකට බැඳුණා කියලා ස්ට්‍රයික් එකට සහභාගී වුණා කියලා සේවකයෙක් අයින් කළා. right? කවුද අයින් කළේ? සිලෝන් කෝල්ඩ් ස්ටෝර්ස් ලිමිටඩ් කියන එක. ඒකේ යූනියන් එක තමයි සිලෝන් මර්කන්ටයිල් යූනියන් එක තිබුණේ. මේ ප්‍රොබේෂන කාලේ හිටපු කෙනත් යූනියන් එකට බැඳිලා හිටියා. යූනියන් එක ස්ට්‍රයික් ක්‍රියාවලියක් වැඩ වර්ජනයක් පටන් ගත්තා. මේ පුද්ගලයාත් ඒ වැඩ වර්ජනයට ගියා. ආයතනය මොකද කළේ? මෙයා ප්‍රොබේෂන් මේ පීරියඩ් එකේ ඉන්න කෙනෙක් වැඩ වර්ජනය කරා කියලා මෙයා රස්සාවෙන් අස් කළා. දැන් අස් කළාම මේ අස් කිරීමට එරෙහිව කම්කරු දෙපාර්තමේන්තුවෙන් පැමිණිලි කරාම දෙපාර්තමේන්තුව කිව්වා වැරදි මේක නැවත මෙයාට සේවය දෙන්න ඕනේ. ඒ කම්කරු දෙපාර්තමේන්තුවේ දෙන තීරණයකට එරෙහිව හාම්පුතෙකුට පුළුවන් රිට් ආච්චාවකට යන්න අපීල් කෝට් එකේ. court of appeal වල. Right? So employer can go to court of appeal against the decision of the Commissioner General of Labour. So he went, and the court of appeal affirmed tahawuru kala the decision given by the Commissioner General of Labour. That means the Commissioner General said the company that you are wrong, he has the right, and then therefore reinstate him නැවත සේවය පිහිටුවන්න ඕන with back wages. That decision, against that decision, the Ceylon Coal Stores Limited went to the Court of Appeal, and the Court of Appeal finally affirmed the decision of the Commissioner General. Again, against the decision given by the Court of Appeal, the employer can go to leave to appeal. It means to the Supreme Court. It is called leave to appeal. Right? Supreme Court. That is the highest court. The court, Supreme Court, judge said that, yes, he has right. Confirm කරපු. එහෙම නැත්නම් ස්ථිර කරපු සේවකයෙකුට තියෙන අයිතිය හා සමානව ප්‍රොබේෂන් පීරියඩ් එකේ ඉන්න කෙනෙකුටත් වෘත්තීය සමිති වලට බැඳෙන්න ස්ට්‍රයික් කරන්න අයිතිය තියෙනවා. දැන් ඔබ තේරුම් ගන්න ස්ට්‍රයික් කරන්න අයිතියක් තිබේ කියන එක නීති පොතේ කම්කරු නීතියේ පැහැදිලිව වචන වලින් සඳහන් නොවුනට ලියලා නැති වුණාට උසාවි මගින් තහවුරු කරලා තියෙනවා නඩු තීන්දුව මගින් තහවුරු කරලා තියෙනවා ස්ට්‍රයික් කිරීමේ අයිතිය පුද්ගලයන්ට තියෙන බව. Is it clear or not?
Clear, sir.
Right. Whether probation, right. The answer is yes. Yes, yes, the probation has, yes, the probation has the right to strike. The probation has the right to strike. The probation has the right to strike. Full stop. The Industrial Dispute Act or the Industrial Dispute Act or Trade Union Ordinance do not have.
Sorry, sir, can you repeat the dispute act or trade?
And not or Industrial Dispute Act and Trade Union Ordinance trade unions, ordinance, union ordinance, do not have explicit provisions. Explicit can prakasita, ලියලා තියෙන. Explicit provisions. Saying that a workman has a workman has the right to strike, the right to strike. However, superior courts in Sri Lanka have recognized the right to strike. Right, next para. In the case in the Supreme in the Supreme Court case, in a Supreme Court, in the Supreme Court case, in the Supreme Court case put it as Ceylon Mercantile Union. You see this one, huh? Ceylon Mercantile Union, V means versus. Ceylon Coal Stores Limited. Ceylon Coal Stores Limited and another within bracket CS. CS means Supreme Court. Close the bracket. Put a dash. 1995. Again within bracket 1. Eka. Close the bracket. Sri, SRI. And then LR, L capital, R capital. 261, comma. Page 270. Comma. The Supreme Court judge, the Supreme Court, comma, the Supreme Court judge has said, S-A-I-D, said, has said that probationer has as much a right to strike as a confirmed, again, savior sthira karapu කියන confirmed workman, confirmed workman, full stop. ඒ කියන්නේ ස්ථිර කරපු සේවකයෙකුට හා සමානවම probation කෙනෙකුට strike කරන්න අයිතියක් තියෙනවා. Probation has as much a right to strike as a confirmed workman. Right? හොඳයි. ඊළඟට අපි කතා කරන්නේ මම සිංහලෙන් ටිකක් පැහැදිලි කරලා ඉංග්‍රීසියෙන් කියන්න. එතකොට තේරුම් ගන්න ලේසියිනේ. Union recognition. ඒ කියන්නේ union පිළිගැනීම කියන එක. වෘත්තීය සමිති පිළිගැනීම. කවුරු විසින්ද? හාම්පුතා විසින්. යූනියන් එකක් හාම්පුතාට පිළි නොගෙන ඉන්න බෑ. යම් යම් කොන්දේසි සම්පූර්ණ කරලා තියෙනවා නම්. ඒ කියන්නේ යූනියන් එකට රෙකග්නයිස් කරන්න ඕනේ, පිළිගන්න ඕනේ යූනියන් එක හාම්පුතා විසින්. ඒ යූනියන් එකට ඒ අදාළ ආයතනයේ වැඩපොලේ වැඩබිමේ ඕගනයිසේෂන් එකේ ඒ හාම්පුතාගේ එතන වැඩ කරන සේවකයන්ගෙන් 40%ක සේවක සංඛ්‍යාවක් යූනියන් එකේ සමාජිකයෝ නම් යූනියන් එකේ සමාජිකයෝ නම් ඒ යූනියන් එක හාම්පුතා සමග භාගයෙන් කරන්න කේවල් කිරීමට කරනු ලබන ඉල්ලීමක් ප්‍රතික්ෂේප කළ නොහැකිය. ඒ කියන්නේ යූනියන් එකේ පිළිගන්න ඕන කියන්නේ. 40%ක් තියනවද කියලා බලන්නේ හාම්පුතා පිළිගන්නේ නැත්නම් 40%ක් තියනවායි කියලා කම්කරු දෙපාර්තමේන්තුව රෙෆරන්ඩා එකක්. ඒ කියන්නේ ඡන්දයක් පවත්වනවා, රහස්‍ය ඡන්දයක් දෙපාර්තමේන්තුව ආයතනයට ගිහිල්ලා මාසය ඉල්ලීමක් ලැබෙන්න ඕනේ රෙෆරන්ඩම් එකක් නැත්නම් ඡන්දයක් තියන්න කියලා යූනියන් එකෙන් හරි හාම්පුතාගෙන් හරි. එහෙම ලැබුණාම ඒක මාසයක් ඇතුළත ඒකට දිනවකවානු වෙන් කරලා ආයතනයට ගිහිල්ලා එදා දවසේ ඒ සේවකයන්ගෙන් ඡන්දයක් පවත්වනවා. යූනියන් එකට පක්ෂද විපක්ෂද කියලා. එතකොට ඒ මුළු සේවක සංඛ්‍යාවෙන් 40%ක් ආයතනයේට, ඒ කියන්නේ යූනියන් එකට පක්ෂයි කිව්වොත් ඒ කියන්නේ මෙම්බර්ෂිප් එක තියෙනවා 40%. right? එවැනි වෙලාවක ඒ යූනියන් එක රෙකග්නයිස් කරන්න ඕනේ. මේ 40% රූල් එක ගේන්නේ 1999 අවුරුද්දේ ඉන්ඩස්ට්‍රියල් ඩිස්පියුට් ඇක්ට් එක සංශෝධනය කිරීමෙන්. එකට අපි කියනවා Industrial Dispute Act number 56 of 1999. 1999 අංක 56 දරන කාර්මික රවුල් පනත, සංශෝධිත පනත. So, union recognition. Let me explain in English. The 40% rule on trade unions derived through the Industrial Dispute Act number 56 of 1999 amendment recognized that where a trade union represents more than 40% of workmen on whose behalf the trade union seeks to bargain, the employer cannot refuse but recognize the union and call upon for measures to mitigate and solve such matters. So, According to the Industrial Dispute Amendment Act number 56 of 1999, if employer has, sorry, trade union, right, has 40% membership, we call it threshold, 40% membership of the total workforce. And then the union can bargain with the employer, right, on behalf of their members, and the employer has to recognize it. Is it clear or not?
Clear, sir.
Avisa?
Clear, sir.
Right. So union recognition, right? As per the provision, as per the, I will little bit change, right? This wordings. You know, in order to, you know, in order for the, I mean, for easy understanding, right? As per the provisions of Industrial Dispute Act, within bracket amendment, Industrial Dispute Act, within bracket amendment, close the bracket, number 56 of 1999. The employer has to recognize and cannot refuse to bargain the union which is representing at least 40% which has, sorry, not which is, which has at least 40% or more members right, members of the total workforce in that particular workplace, organization. Is it clear? I hope it is clear.
Excuse me, sir. Mic is muted.
Sorry about that. Sorry. Yeah, by mistake. Then next subtopic is trade union action. Trade union action. වෘත්තීය සමිති ක්‍රියාමාර්ග ක්‍රියාකාරකම් action. වෘත්තීය සමිති විවිධ අරමුණු ඉටු කර ගැනීම සඳහා වෘත්තීය අරගලවල යෙදෙනවා. Trade unions විවිධ ක්‍රියාකාරකම් වල යෙදෙනවා. එකක් තමයි තමන්ගේ ඉල්ලීම් සේවා නියම සහ කොන්දේසි සම්බන්ධයෙන් වන ඉල්ලීම් දිනා ගැනීම. Just give me 1 minute. Sorry, I just attend to a call. Sorry. Trade union action. මේගොල්ලෝ විවිධ ක්‍රියාකාර මොනවද? එකක් තමයි තමන්ගේ ඉල්ලීම් දිනා ගන්න. ඊළඟට demonstrate disagreement. තමන්ගේ මොනවද? various විවිධ issues සම්බන්ධයෙන් සමහරට හාම් පුතා ගන්න තීරණ හෝ දේවල් සම්බන්ධයෙන් තමන් එකඟ නොවෙනවයි කියන එක පෙන්වන්න. right? ඒ වගේම industrial dispute එකක් ආවහම ඒ industrial dispute කාර්මික ආරවුල් සම්බන්ධයෙන්. ඒ වගේම වෙනත් යූනියන් එකකට සපෝට් කරන්න. තවත් යූනියන් එකක්. යනවා. ඒ වගේම තමයි political reasons. These are the trade union actions. Okay? පැහැදිලිද?
Oh, sir.
Right. Take your note. Trade union action. Right? Trade union actions are measures. Trade union actions are measures. Taken by trade unions as collective efforts collective efforts for various motives. For various motives, such as don't put 1, 2, 3, just bullet, bullet form or star mark. First bullet. To win demands, to win demands, illim. Relating to terms and conditions of employment. Seva niyama saha kondesi, seva kondesi. Next bullet. Demonstrate disagreements stroke discontentment, 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 relating to various issues. Next bullet form. For matters relating to industrial disputes. Next, to support other trade unions. Last but not least, ඒක ලියන්න එපා ඊළඟ බුලට් එක කියන එකයි කිව්වේ. For political reasons. හරි. Right. The next slide in this presentation talks about restrictive provisions of the trade union ordinance on right to strikes. There are some restrictive provisions of the trade union ordinance on right to strike. ඒ කියන්නේ සීමාකාරී ප්‍රතිපාදන වැඩ වර්ජනය කිරීමේ අයිතිය සම්බන්ධයෙන් වෘත්තීය සමිති ආච්ඡාපනතේ තියෙන සීමාකාරී ප්‍රතිපාදන. සරල භාෂාවෙන් කිව්වොත් ඉස්සෙල්ලාම essential industry එකක් හැටියට යම්කිසි ඉන්ඩස්ට්‍රි එකක් ගැසට් කරොත් ඉන්ඩස්ට්‍රි එකක් හැටියට essential අත්‍යවශ්‍ය ව්‍යාපාරයක් හැටියට ගැසට් කරොත් අන්න ඒකේ ස්ට්‍රයික් එකක් කරනවා නම් එහෙම ගැසට් කරපු අත්‍යවශ්‍ය ව්‍යාපාරයක් අත්‍යවශ්‍ය ඉන්ඩස්ට්‍රි එකක් කර්මාන්තයක් කියලා ගැසට් කෙරුවොත් ඒ ගැසට් කිරීම හේතු කොටගෙන ඒ අදාළ ඉන්ඩස්ට්‍රි එකේ කණ්ඩායමක් වර්කර්ස්ලා යූනියන් වැඩ වර්ජනයකට යනවා නම් ඒ වැඩ වර්ජනය කරන දිනට දින 21කට කලින් ඒ බව හාම්පුතාටත් කම්කරු කොමසාරිස් ජෙනරාල්වරයාටත් ලිඛිතව දන්වන්න ඕනේ. මේක අදාළ වෙන්නේ ප්‍රයිවට් සෙක්ටර් එකේ අයට සහ රාජ්‍යාංශයේ අයටත් මේක අදාළ වෙනවා රාජ්‍ය ආයතන සම්බන්ධයෙන් ගත්තත් මොකද වෘත්තීය සමිතිය අයිතිය රාජ්‍ය ආයතන වලටත් තියෙනවනේ. essential industry එකක් හැටියට කම්කරු අමාත්‍යවරයා ගැසට් කළොත් දැන් මහජන ආරක්ෂණ පනත යටතේ අතිගරු ජනාධිපතිතුමා ගැසට් කරනවා. ඒක යටතේ ගැසට් කරොත් ආයේ ස්ට්‍රයික් ඒව මොකුත් බෑ. මේ ට්‍රේඩ් යූනියන් ඕඩිනන්ස් එක යටතේ අත්‍යවශ්‍ය එකක් කියලා ගැසට් කරුවොත් ලේබර් මිනිස්ටර් අන්න ඒ වගේ වෙලාවල් වලදී දින 21කට කලින් දැනුම් දෙන්න ඕනේ. right. ඒ වගේම hari. So what industrial the trade union ordinance says a strike is in an essential industry අත්‍යවශ්‍ය ව්‍යාපාරයක් must be preceded එක පටන් ගත යුත්තේ by a written notice 21 days prior to the commencing of the strike in the prescribed form of the intention to commence the strike. ලිඛිතව දැනුම් දෙන්න ඕන. Essential industries are industries declared by the Minister of Labour through a gazette publication or notification. And then section 41E says, when workmen are bound by a collective agreement, a settlement or award an arbitrator or award by award of an arbitrator or industrial court taking part in a strike with a view to amend those agreements, statement award is restricted. මේක තියෙන්නේ industrial dispute act එකේ. right. The trade union ordinance, right? Industrial dispute act එකෙත් මේක තියෙනවා. ඒ කියන්නේ ඔබ දන්නවා industrial dispute act එක යටතේ conciliation fail වුණොත් සමතකරණය fail වුණොත් ඊට පස්සේ ස්වේච්ඡා වේරුම් කරනවා. ඊට පස්සේ අනිවාර්ය වේරුම් කරනවා. නැත්නම් labor court, right? ඒවයින් දෙන්නේ award නේ. Award is granted. So no one can undertake strikes to change or amend the award of an arbitrator or an industrial court given in relation to an industrial dispute. ඒක කරන්න බෑ. පැහැදිලිද?
Yes, sir.
And it is not allowed for workmen to take part in a strike to secure alternation to an order by a labor tribunal. Labor tribunal එකේ labor tribunal යන්නේ මොනවා වුණාමද? සේවය අවසන් කළාම යන්න පුළුවන්. වෙන සේවකව 15ට වඩා අඩු ආයතනයක පාරිතෝෂික හිමි කෙනෙකුට මොකද පාරිතෝෂික පනතෙන් සේවකව 15ට වඩා අඩුයි නම් ආවරණය වෙන්නේ නැහැ. එයාට Tamanට පාරිතෝෂිකයක් ඕනයි කියලා ඉල්ලාගෙන යන්න පුළුවන් LT එකට. හරිද? ඊට අමතරව තමන්ගේ පාරිතෝෂිකය හරියට ගණන් හැදුවේ නැහැ කියලා ඒකට විරුද්ධවත් LT එකට යන්න පුළුවන්. ඉතින් මේ LT එකෙන් දෙන ඕඩර් එකකට විරුද්ධව ඒක වෙනස් ඒක ඕල්ටර් කරන්න ඒක වෙනස් කරන්න කියලා ස්ට්‍රයික් කරන්න බෑ. ඒක තහනම්. And then it is not allowed to take part in strikes if the dispute is referred for settlement to an industrial court or arbitration, but before such award is made. යම්කිසි කාර්මික ආරවුලක් බේරුම් කරණය සඳහා කම්කරු කාර්මික අධිකරණයකට යොමු කර ඇති විටක කිසිසේත්ම ඒ කාරණය වෙනුවෙන් ස්ට්‍රයික් කරන්න බෑ. ඒ තීරණය දෙන තෙක්. ඒකනේ කරන්නේ ලොකු ස්ට්‍රයික්ස් තියෙන වෙලාවල් වල ස්ට්‍රයික් එක සෙටල් වෙන්න නැත්නම් මිනිස්ටර් කරන්නේ බයි පෝස්ට් දානවා ආබිට්‍රේටර්. දාපු ගමන් සේවකයෝ වැඩට යන්න ඕනේ. ස්ට්‍රයික් කරන්න බෑ. අර තීරණය දෙන තෙක්. ආම්බුදා වැඩ දෙන්නත් ඕනේ. Okay? That is what it says. I hope you understand. Right. Restrictive subtopic. Restrictive provisions of the trade union ordinance on right to strike right. First bullet. A strike in an essential industry must be preceded, P-R-E-C-E-D-E-D, preceded by a written notice, within bracket 21 days prior to the commencing of the strike, close the bracket. 21 days prior to the commencing of the strike, close the bracket. In the prescribed form. එකට වෙනම ෆෝම් එකක් තියෙනවා. ඒ ආකෘතිය පනතෙම තියෙනවා. Prescribed form of the intention මොකද්ද බලාපොරොත්තු අරමුණ intention to commence the strike. දින 21කට කලින් දැනුම් දෙන්න ඕන මෙන්න මේ හේතුව නිසා අපි ස්ට්‍රයික් එකකට යනවායි. Commence the strike. Just 1 second. This notice should be communicated to the all parties concerned, within bracket, the employer, The employer, comma, Commissioner General of Labor, right, close the bracket. Next para, don't put another bullet, next para. Essential industries are industries, because still we are discussing the first bullet form, first form. Essential industries are industries declared by the Minister of Labor through a gazette notification. Gazette notification. Right. Next bullet. Next bullet. When workmen, sevakayan, are bound by, බැඳී සිටිනවා නම්, are bound by a collective agreement, සාමූහික ගිවිසුමකින්, stock, ඇලයිරක්, settlement, සමතකරණයක්, stroke, award of an arbitrator, or industrial court, බේරුම්කරුවෙකුගේ ප්‍රදානයකින් හෝ කාර්මික අධිකරණ ප්‍රදානයකින්. ඒ කියන්නේ යම්කිසි සේවක කණ්ඩායමක් සාමූහික ගිවිසුමකින් හරි සෙටල්මන්ට් එක සමතයකින් හරි ඒ වගේම ආබිට්‍රේටර් විසින් දෙන ලද අවෝඩ් එකකින් හරි ඒ කියන්නේ ප්‍රදානයකින් හරි කාර්මික අධිකරණයකින් දෙන ප්‍රදානයකින් හරි බැඳී සිටිනම් taking part in a strike with a view to amend those agreements, settlement, award is restricted. ඒවා වෙනස් කරන්න කියලා strike කිරීම තහනම්. Right. So, comma, industrial court, comma, taking part in a strike. Taking part in a strike. Taking part in a strike with a view to amend වෙනස් කරන කියන්නේ ඒවා සංශෝධනය කරන amend those agreements, stock settlements, stock awards is restricted. Tahanam is restricted. Next bullet. Right. Next bullet. It is not allowed. It is not allowed. It is not allowed for workmen for workmen to take part in a strike. To take part in a strike. To secure alterations. Alteration කියන එක තේරෙනවනේ නේද? අපි අඳුමක් වාන්න ගියත් මේක හරියට පිට කරගන්න නැත්නම් වෙනස් කරගන්න වෙන එකනේ කියන්නේ alteration, right? Alterations. Strike to secure alterations. Alterations to an order. දෙන ලද order එකකට. To an order given by a labor tribunal. Labor tribunal. කම්කරු විනිශ්චයාධිකාරියක් මගින් දෙනු ලබන තීරණයක් වෙනස් කිරීම සඳහා බලපෑම් කිරීමට ස්ට්‍රයික් කිරීම සපුරා තහනම්. Right. Next bullet form. Right. It is not allowed to take part in a strike. In a strike. If the dispute is referred for settlement to an arbitration, to an industrial court or arbitrator, comma, but before such award is made, යම්කිසි ආරවුලකට අදාළ කාරණයක් බේරුම් කරණයට යොමු කරාම හරි කාර්මික අධිකරණයට හරි යොමු කරාම ඒකේ තීරණය දෙනකන් ස්ට්‍රයික් කරන්න බෑ. තීරණය දුන්නාට පස්සේ පුළුවන්. දැන් ස්ට්‍රයික් එකක් යන වෙලාවක බොහෝ වෙලාවට අපි සෙටල් වෙන්නේ නැත්තම් සමතේට එන්නේ නැත්තම් ස්ට්‍රයික් එක නවතින්න නැත්තම් දානවා අපිට. දාපු ගමන් මොකද වෙන්නේ? ස්ට්‍රයික් එක නවත්තලා වැඩට යන්න ඕනේ. Okay? Next. Types of strikes. Next subtopic, types of strikes. So, could you please, you can take your own note. So, just one second. Oh my God. Just 1 minute, 1 second. Is it visible? Kavisa, is it visible?
Yes, sir, visible.
Right. So types of the strike. These are the types of the strikes. There may be some other, but partial strikes, stay in or sit down strike, sympathy strikes, boycott, go slow, work to rule, picketing, lookouts, overtime bans, reporting sick, අසනීපනේ ඉන්නවා කියලා කියන්නේ ඒවා. These are the types of strikes. So you take your own note. I'll give you 5 minutes. මේක ලියා ගන්න. Once you finish, let me know.
I'm finished, sir.
What about the other?
Kavisha, I don't know, Kavisha.
Yes, sir, I also finished.
Right. Now, what do you mean by these parcel strikes? Parcel strikes strikes වැඩවැරුමනේ. Parcel කියන්නේ අර්ධේව භාගයට කරන. ඒ කියන්නේ දවසේ පැයක් සමහරවිට. Right. එහෙම නැත්නම් කොටසක් වැඩට යනවා කොටසක් ස්ට්‍රයික් කරනවා. Right. අර්ධ වශයෙන් කරනවා. ඒවා එකක් එහෙම මතක තියාගන්න ඕනේ නැහැ. Stay in, sit down. කියන්නේ they go to work, maybe inside or outside. They don't work, just sit down. They don't work. Sympathy strikes. You know, they undertake a strike action, you know, to tribute to someone, right? එහෙම නැත්නම් අවධානය ගන්න වෙන්න පුළුවන්. තව වෙනත් එක කෙනෙකුට tribute කරන්න. ඒ කියන්නේ ඒකට අගය කරන්න. හරිද? Sympathy strikes. Boycott means really strike. You don't go to work. You undertake, you know, just you don't work and it's organized, the trade union, you listen to what trade union said, leaders say, and you act accordingly. That is real strike. Go slow. Go slow is you are reporting to work, but you are not giving the target. You purposely delay the production. You go, right, within 8 hours, there are certain works that you have to perform, but you do not do it. Say, for example, in a normal situation, if you were supposed to perform, say, the X number of, you know, the work, ඇඳුම් මහනවා නම් ඇඳුම් 5ක් හරි 10ක් මොකක් හරි. So you do not give the target. Purposely delay the target. That is go slow. This go slow is not a strike in Sri Lanka. Go slow is not a strike in Sri Lanka. It is called misconduct. It is called misconduct, leading to take disciplinary action. Who is saying? Not me. Supreme Court judgment. In 2006, if I'm not mistaken, Varaya Sevuk, the harbor workers, they went on go slow. They reported to work, but they didn't, you know, clear, you know, the container, not up to the, even not 50%. And then the JAF, if I'm not mistaken, Joint Apparel Association Forum, on behalf of the exporters, they went to court saying that their fundamental rights are violated because they were struggling to clear the raw material. The production process was affected. They were struggling to send their export on time, because if you do not send your exports on time, next time there is no demand for your goods. They will decline it and they will not give an order. I mean, the demand. The purposely, what I say, the harbor people, they didn't do it. They just did something. And then went to the Supreme Court. Supreme Court said that it is eka hituakkara krama. It is purposely, if you are reporting to work and you have to fulfill the task. If you are not doing it, it is a misconduct, which is leading to take disciplinary action. පවුදාම ගෙදර එලවන්න පුළුවන්. ඒ නිසා ගෝස්ලෝ කියන්නේ ලංකාවේ ස්ට්‍රයික් එකක් නෙමෙයි. ඒක කඩාකප්පල්කාරී ක්‍රියාවක්. විනය විරෝධීව කටයුතු කරන්න පුළුවන්. Work to rule. Yes, okay. Legal strike. Right? Strictly. The trade union or workers is strictly interpreting their contract of employment. පැයටයි පැයටේ හරියටම වැඩ කරා. ඕ ටයිම් නෑ. වැඩ කරන්න වෙන වෙලාවල් වල එන්න කිව්වට එන්නේ නෑ. පැයටේ කරන්න ඕන ටාගට් එක කරනවා. Strictly, restricting to the prescribed work. That is work to rule. අකුරට වැඩ කරනවා කියන්නේ පැයට විතරයි. ඕ ටයිම් නෑ. වැඩ තිබ්බත් එකයි නැත වැඩ ගොඩ ගැහිලා තිබුණාට කරන්න දෙන්න. පැයටේ නියමිත වෙලාවට වැඩ කරා ගියා යන්න. right? අමතර වැඩ කරන්නේ නැහැ. බලහත්කාරයෙන් මහන්සි වෙලා අනේ මේ වැඩ තියනව නේද කියලා දුවලා පැනලා කන වෙලාවක් ගන්න නැතුව එහෙම වැඩ කරන්නේ නැහැ. හරියටම තමන්ගේ වෙලාවේ වැඩ කරා ගියා යන්න. That is work to rule. ඒක legal. Picketing, කෑම පැයේ picketing is legal. Lockouts කියන්නේ හාම්පුදාගේ පැත්තෙන්. මේකට කියනවා දොරගුළු ලෑම් නැත්නම් දොර වැසුම් කියලා. The employer close the door. When you go to work, employer close the door. Lockouts happen because of the action of lockout is done by the employer, not the workers. The strikes are done by the workers, but lockouts also types of strikes. In order to say the disagreement, right? Sometimes, say for example, Labor Department give an order with regard to certain group of people, right? They went on a strike, but Labor Department insist and ask the employer and they give the decision to the employer to take them, the back. In order to show the disagreement for the decision, employer can close this is not for a longer period, but maybe for 2-3 days. Right? That is lockout. And overtime bans from the workers' side. They banned overtime. That is also legal. And reporting sick, yes, legal if they have sick leave. If they have leave, whether it is sick or not, if they have leave. Okay, understood? Is it clear?
Yes, sir. Yes, sir. All types are clear.
Okay.
Yes, sir.
And the collective bargaining definition. This is, something else. You can read it out later. Collective bargaining definition of ILO Convention 154, Article 2, conditions for collective bargaining and compulsory bargaining. This is we have already, this is important. No employer, compulsory bargaining, right? No employer shall refuse to bargain with a trade union which has in its membership not less than 40%. මේක කලින් කිව්ව මතකද? 140ක් තියෙනවා නම් right? ඒක ඒ 140ක membership එකක් තියෙනවා නම් මොනවා කරන්න බැරිද? bargain කරන්න ඉල්ලන එක refuse කරන්න බෑ. ඒ trade union එක පිළිගන්න. Already discussed this one, right? Already discussed. So, ladies and gentlemen, thank you for your active participation. This contains altogether 101%, almost, the content is 100. Last one is thank you. So this will be uploaded Today I will send this, and this is a material, very comprehensive material I have prepared, and keep it with you. And I hope you have understood. We have just 5 minutes, and I have another Zoom meeting at 12 o'clock. So therefore, I need at least 5 minutes break. So almost 11:55. I hope you understand, right? You understood everything. Am I correct?
Yes, sir. Sir, can I get Dilini's contact number?
Whose contact number?
Dilini, excuse me, Dilini.
Yes, Dilini.
Yes, Kavisha.
Can I get your contact number? Can you tell?
Okay.
Yeah.
Note 76
Yes.
35
35
28
28
916.
916. Thank you. I will send you a message. Thank you, sir.
Okay. Have a good day. Right.
Thank you, sir. Thank you very much.
Thank you.
Bye.
Bye.
Thank you, sir.
Okay.